Good morning. The District Court of Appeal of the State of Florida in and for the Second District is now in session. The Honorable Robert J. Morris, Jr., Judge presiding. Those having business before this court, draw near, give attention, and you will be heard. May God save the United States of America, the State of Florida, and this honorable court.
Good morning, everyone, and welcome to the Second District Court of Appeal. This is our session for our remote oral argument. I'll call the cases in the order listed on the docket, and when each case is called, there'll be a brief pause as you are transitioned into our virtual courtroom. After each case is completed, the participants are asked to leave the meeting and may continue to view online if they wish. As a reminder, each side is given 20 minutes for oral argument. If you're the appellant, please let me know if you'd like to reserve up to 5 minutes for rebuttal, no more than 5 minutes. Please unmute your microphone when you're recognized to present your argument. Thank you. We're ready to proceed. Our first case this morning is Garcia versus Citizens Property. Are we ready to proceed?
Hey, good morning, Your Honors.
Good morning.
Support.
Would you like to reserve some time for rebuttal?
Yes, please. May I reserve 5 minutes?
Okay.
So, Kurt Rosales, on behalf of the appellants Belkis Garcia and Mario Carpio, we would ask the court to reverse the order granting citizens motion for summary judgment and remand for a trial on the merits. Basically, in this case, we believe we got a premature handling of the proof of loss issue here for two main reasons. Number one, plaintiffs explained their non-compliance with the post-loss condition, in this case, the proof of loss requirement. And number two, citizens failed to plead or prove that plaintiffs' non-compliance was material or prejudiced them in any way. So for those two reasons,
Mr. Rosales, can we go back to their non-compliance? And
sure.
They took a position that the second letter sent by citizens after they initially contacted citizens about the claim to the damage to their roof, their position is that that second letter, they believe, gave them an additional 60 days for the proof of loss.
Correct.
Yet the letter itself does not say that. So would you walk me through that analysis a little bit?
Sure. So as you said, we had a first letter that said, and according to the policy says you have 60 days within after we request a proof of loss to provide a proof of loss.
That's the first letter, right?
That's the first letter.
Okay.
Then we've got a subsequent letter which was received about a month later on August 3rd that says, hey, we need a proof of loss. The position was, as you articulated, that second letter, instead of simply being a reminder, the position is that plaintiffs, specifically the affidavit of Mario Carpio, as well as the rebuttal to the motion for summary judgment, explained that, hey, when plaintiffs received this letter, their understanding, despite the fact, as you say, that there was not an explicit indication that you had an additional 60 days, their understanding was that the letter in and of itself allowed for that 60 days period.
Didn't the letter identify a date by which the proof of loss had to be?
I believe the letter doesn't specifically identify the date for the proof of loss. What the letter identifies is a date for additional documentation. And so, but I believe that because we are at summary judgment here, my position is not that a jury sitting at a trial looking at and making this determination of materiality couldn't decide in favor of citizens. My position is that at summary judgment, where these inferences need to be, looked at in light of the benefit of the party who summary judgment is against, that we can take this inference and we can take this position that Mr. Carpio stated in his affidavit, which is, hey, there were these requests for the proof of loss, and then they denied my claim before I had an opportunity to respond to that proof of loss. And so the position is that regardless of whether a jury could determine materiality of this breach at trial, at summary judgment, that's just simply not appropriate. And I think that's what the case law here backs up. In the Juravat case in 2017 from the second, it simply says that if the insured corroborates to some degree or explains his failure to comply. So we have an explanation of a failure to comply here.
And one of the inferences, I assume that you're, can you hear me all right?
It sounds a little bit fuzzy, Your Honor.
Yeah.
But I think you were asking about the inferences at summary judgment. Is that correct?
One of the inferences is, can you hear now? No?
No, I'm sorry.
Okay. I'll go ahead.
Okay. So my position is basically that the Juravat case, Hyman case, Mirkolos case, 2 out of 3 being from the second, basically just says that, if an insured cooperates to some degree, or in this case, we have an explanation that says, or explains his failure to comply.
Well,
So
let me
we're
ask
not
you a
arguing,
question, Mr. Rosales. I don't mean to interrupt you, and I apologize for that.
Sure.
But when was the proof of loss ultimately provided?
So the proof of loss was not provided until September 26th of 2018.
So several years later.
100%. And again, we're not arguing that there was compliance. We're arguing that there was an explanation for non-compliance, which is
so even though this second letter did not say, oh, by the way, you've got an additional 60 days from this letter, the letter basically reads as in the nature of a reminder. By the way, we need this proof of loss. I don't have the letter in front of me now, but my recollection was it had a date certain by which it should be delivered. And you've told me that's not the case. We should probably take a look at the letter and confirm that. And I would imagine Applee's going to have that letter as soon as they stand up. They'll probably tell us whether it does or it doesn't, then that's helpful. But what's troubling is that under any scenario, this proof of loss was not provided by the date certain. It was not provided by an additional 60 days, which you contend the letter gives, which is just not in the writing of the letter, but it was given 2 years later. So there was there wasn't going to be compliance under any scenario.
Well, I think that we've got I think we have 2 things to look at in that case. So first of all, the case law, Juravat and Mirkolos, doesn't necessarily contemplate that there is compliance, period. It just says, or explains a failure to comply. So here we just have a failure to comply. And the explanation is, hey, we thought that this was going to take place. We thought that we had this extra time frame. Then to answer your second question, that leads us basically into the remainder of the briefs, which is
Materiality.
Sorry?
Well, materiality is a big issue here. Is it material that the proof of loss was not provided timely? And you've made an argument that isn't material, right?
Right, and that leads us to the second argument, which is, well, a few other arguments, which is number 2, during this supposed period of time where plaintiffs believe that they had this additional time frame, Citizens denies the claim. And they deny the claim not based off that this goes towards materiality. They don't deny the claim and say, hey, you failed to provide us with a proof of loss. They deny the
Well,
claim and say,
As I understood that, what happened was is the homeowners hired a roofer. And the roofer, basically took the position that hail damaged the roof. Citizens sent out an inspector, looked at the roof, and basically took the position it doesn't look like hail damaged this roof. That wasn't an outright denial of a claim. It was an expression of doubtfulness about the veracity of the claim, and that the claim was ultimately denied, the way I've read this record, after the time for the proof of loss had run and not been provided. Citizens took the position, you haven't provided the proof of loss, we're denying the claim. Is the way I've read this. So help me, where you think it was denied in a different scenario than I've outlined. So pinpoint me to that scenario.
sure. So I'm looking at, and I don't have the letter pulled up, but I'll pull it up in rebuttal if need be. But I'm looking at a September 10th, 2015 letter where Citizens claims that denies the claim and says that they deny the claim for failure to report the loss in a timely manner. And this is going back to the fact that the loss
Occurred a year earlier.
right, it occurred about a year earlier. And I'll pull up, I actually have more notes on that, but basically the whole premise of this denial letter was due to the delay in reporting of the claim. And if you want to make a notes, I've got record sites here to 239 and then 252 to 255. And Citizen repeats this at least 3 times in this letter. They say failure to report the loss in a timely manner, due to the delay in the reporting of the claim. So we have a denial that has nothing to do with the proof of loss. And I believe that in and of itself goes to the materiality here. Further, we can take a look at the deposition of Citizens' corporate representative. And that corporate representative ensures us in several ways that the proof of loss in and of itself was not required here, that it didn't hamper their investigation in any way.
Well, it's required by the contract, the insurance contract. It basically, spells out if you want to be successful in making a claim, here are the things you have to do, and one of them is to submit this proof of loss within a certain time frame.
Right.
So, whether it is, material from the standpoint of a factual analysis, it's a requirement of a contract.
Agreed, but again, we do have case law that kind of softens that blow for plaintiffs. So that's why we have partial compliance versus full compliance.
But one of the things that judges aren't supposed to do is rewrite the party's contract, right? That's pretty much bedrock case law, right?
I agree.
I mean, there's tons of cases that would say judges should not busy themselves of rewriting a contract between parties, and that's what an insurance policy is. It's a contract.
I agree, but
the contract clearly says, you want to perfect a claim, this is what you have to do, and this is the time frame within which you have to do it. And it's undisputed that didn't happen here, right?
I would say, well, it didn't happen within that time frame. But when
it ultimately happened, it was years later. I mean, not even close to the time frame.
I would agree that if we were looking at this without the benefit of years and years of case law, that would be the case. But in the brief,
can I ask you about that case law?
Sure.
You said there's case. Can you hear me?
Yes.
Yeah, you're perfect now.
Oh, okay. You said there's case law that softened this contractual requirement. Now, is that in the context of a condition precedent to filing suit? And by soften it, I infer you mean to require that the failure of a condition precedent has to prejudice the opposing party. Is that case law in the context of condition precedent to filing suit, or are there cases that you can cite where there is a requirement in an insurance contract that a proof of loss or that type of condition be met before a claim is covered?
I think that they go hand in hand. I think that in my estimation, at least, the condition precedent basically is what perfects the contract, right? And so there is no coverage until those conditions are met, typically.
Right, and you said there's case law that says you have the party invoking that condition precedent as a bar to something, a bar to filing suit or a bar to covering a claim, that has to be prejudicial.
Correct.
Are those cases in the context of a condition precedent to filing suit, or are there cases in which a proof of loss or some such requirement is necessary in order to get coverage, and the insurer has to prove that they were prejudiced by the failure?
Right. So I believe it's in the second instance that you're referring to, but all in all, the proof of loss requirement kind of folds in together, right? So you before you can file, first you need to be able to file suit, in which you need to perform the conditions precedent, and then you can deal with the coverage issue. Because basically, if you don't perfect the contract with the conditions precedent, then you don't even get to the second argument. So I think that the case law, by saying, hey, there needs to be materiality here, while that goes to show that materiality so that an insured can't deny coverage based off of that, in this case, there's no proof of loss. I think that also goes to the fact that, hey, you still get your foot in the door and you still get to have a jury decide whether there's coverage here, whether you can even be in this position.
I mean, your case wasn't dismissed because it was a condition precedent that failed for the purpose of bringing the suit. Your case was resolved against your client because there was a condition precedent to coverage in the contract.
Sure, and so it was basically gotten rid of at summary judgment. But if we look at Eurovat and we look at Miraculous, we're also in that summary judgment context where
Rosales, you're at 15.5 minutes, just so you know. Use your time as you want to.
Okay, I'll save the remaining time for rebuttal. Thank you.
Okay.
Good morning. May it please the court. Jonathan Franklin on behalf of Citizens Property Insurance Corporation. With respect, Belkis, Garcia, and Maria Carpio failed both in letter and spirit here to abide by the policy terms. The policy makes plain that the insured must comply with all the provisions, which would include the duties after loss, and also providing timely notice. Now, the claim is alleged to have occurred in May 2014. The first notice of this loss comes 13 months later, and Citizens issued its July 2nd letter indicating it was reserving its rights based upon the late notice and asking for documentation and a proof of loss. Once those were asked for, they triggered a requirement for the insured to comply with those requests. In this situation, on 2 July 2015, the proof of loss was requested and it was due August 31st, 2015. A month later, after not receiving anything from the insured, Citizens sought out and wrote them again. And I believe Judge Morris, you had asked about the letter. And the letter said this will serve as a follow-up to the acknowledgement letter sent on July 2nd, where we requested information for the claim referenced above. This letter will provide you with the summary of the information we need from you. And it went through again, asking for the signed proof of loss, supporting documentation, photographs, receipts, invoices, canceled checks. It then continued into your point about the day or the date. It says if additional information is not received by September 2nd, 2015, we'll make a determination on your claim based upon the information we have in your file. That was a few days after the 60 days would have expired under the July 2nd letter. When nothing came in at that point, Citizens wrote the insured, and that letter went out on September 10th, 2015. Now, there are a couple of things that have occurred here today and throughout the briefs and the underlying litigation. Garcia and Carpio are not disputing that they received these letters. They're not disputing the contents of the letters. They're not disputing that they complied with these requests. In fact, they concede they didn't comply with them. And again, today, I believe the terms were, we're not arguing compliance, we're arguing explanation. The September 10, 2015 letter takes the point of walking through the historical aspects of the claim in terms of a loss alleged to have occurred in May 2014, efforts to determine the damages. And it says here, we requested information, documentation from you that would have allowed us to further evaluate and determine coverage for your claim. To date, we have not received a response to our request. Due to the time that has elapsed between the date of the loss and the filing of claims, Citizens' ability to investigate this claim has been prejudiced. Citizens then goes through and quotes the policy language for duties after loss and makes a concluding point for the insured. Compliance with these duties are conditions preceding in considering your claim for damages. So what we had here was a situation in September 2015 where the insureds hadn't complied with anything and Citizens denied their claim. Now, I believe, Judge Morris, you asked about, did they file a proof of loss or submit anything before suit? They didn't. And to the point about, is this a material breach? The cases, and for example, I apologize, I know the shortened name, it's Hunt, and I will find the actual full citation to it in a moment, refer to a situation, that's Hunt versus State Farm from the 4th DCA, where there's a condition preceding and a breach occurs in not complying. If the insured complies before filing suit, we deal with a balancing act of prejudice. But if they file suit without complying, the court in Hunt states that it is a material breach. I think there's no dispute here that the breach or the failure to provide the proof of loss was material in this instance. The insureds have offered no explanation as to why they didn't comply with the request. I appreciate an attempt to suggest that they were under the impression, but the only piece of evidence that Carpio and Garcia provided was an affidavit dated September 26, 16 November 2018. And it goes through and says, we had a loss of some type of damage on May 26. We got the letter from Citizens. And then it goes into, and it says this, before a sworn proof of loss could be completed, Citizens sent correspondence dated September 10, 2015, denying the claim. That does not offer an explanation. That does not explain away their situation. There's not a scenario here where they ask for more time or they said, we'll get this to you. All this does is says before they deny the claim, we just didn't get it completed. That's not a valid explanation, and that doesn't meet the requirements for the court in terms of the case law that's referenced here. The situation presented here was a summary judgment for the trial court. Incredibly, Garcia and Carpio concede they didn't comply with anything in terms of the request for the documents, in terms of the proof of loss. I would submit if this were a late notice case, the issue of whether it was timely is a jury question. I know that very well, having been involved in several cases on that, on the unsuccessful side. This is not a situation where that occurred. What we do have is the insureds conceding not complying with the policy terms. They're conceding that they filed suit without complying with the policy terms. And it's only after the summary judgment and 9 months after suit that they make the attempt to provide the proof of loss. It doesn't explain the non-compliance. It doesn't offer the documents that were requested, and it offers no explanation for that. With respect, we would submit that the summary judgment was proper. It followed the law in a situation where the insureds concede not complying. We would ask the court to affirm the summary judgment. Unless the court has any further questions, I won't belabor the matter.
Thank you.
So there's
Mr. Rosales, you've got 4.5 minutes.
Okay, so there's a few things that I want to address. The first goes to the compliance issue. So, and it's cited in the briefs. Compliance with this proof of loss requirement, it almost becomes futile where Citizens denies the claim for delayed for the delayed notice of loss. So there's there's case law that I've cited that basically says, hey, once you have a denial, and this is Keel, which Citizens actually cites in their answer brief. Keel says once you have a denial for a reason other than a proof of loss, the submission of a proof of loss is futile. So in this case, as the court has made clear, Citizens went out and got a independent contractor to look at the roof and said, hey, there's no hail damage. Citizens denies the claim or investigates the claim fully, which goes to the materiality of the proof of loss to begin with, and then denies the claim for a reason that has nothing to do with the proof of loss to begin with. It has to do with the delay in the reporting of the claim. Further, Citizens now cites to Hunt, but we know that Hunt is not the law in Florida. As the brief cites, we have this weird situation to where you have the 3rd district agreeing with the 5th district that says, hey, in these situations, materiality is key here. You always have a question of materiality for the jury when you have a summary judgment or where you have this issue with the proof of loss. Hunt appears to be in isolation here. We even have a question, an intra-district conflict in the 5th district, where you have one case, a prior case, stating that the burden to prove this materiality is on the insurer. And then you have the subsequent case, Farmers, which says, hey, the burden of materiality is on the insured, that basically the insured needs to come forth and prove that there is this issue of that there's no material breach here. But all of this takes place in front of a jury. That's the summation of all these cases. That's the summation of Uravat, of Farmers, of Estrada, of Mirkolos, which is basically materiality is a question for the jury. That materiality is not a question to be dealt with on summary judgment. And again, that's why I can say, hey, yes, there was no compliance here, or there was this very late compliance here, but that explanation is what allows us to get to this question of materiality. And or even beyond that, we can look at Farmers, which basically just outright says, it says it's unsurprisingly well settled that there be a total forfeiture coverage under homeowners policy, the failure to comply with post-loss obligations, conditions precedent to trial, the insured breach must be material. This all occurred within the past year. I mean, these cases are 2019 cases from sister districts, which look at this particular situation. I mean, Farmers is very, very close to the facts of this case and say pretty definitively that this is not a summary judgment issue. It's an issue for the jury to look at, for the jury to have the information and determine whether this breach materially affected Citizens and by meaning that hampered their investigation, which we know for a fact wasn't the case because their denial was not based off of this proof of loss condition, and Citizens was able to go out there and get an opinion from a contractor that said the same. We also have the deposition of Citizens corporate representative, which makes clear that they weren't materially affected by this, that their investigation was still able to take place, that a proof of loss is not determinative of the damage, and that they were able to complete their investigation and make a coverage determination without the proof of loss. Because materiality.
You're out of time, Mr. Rosales.
All right, we would ask the court to reverse the summary judgment and remand for the jury to take a look at this and for a trial on its merits. Thank you.
Thank you both, gentlemen. Well argued.
Thank you, Your Honors. Have a great day and be safe.
Next case is Lincare versus Ford. I think we have everybody, Ms. Norris and Mr. Donovan. Good morning. So we are, Ms. Norris, would you like to reserve 5 minutes?
I would, Your Honor. Thank you.
Okay, we're ready whenever you are.
May it please the court, my name is Kristen Norris, and together with Stuart Markman of Kynes, Markman & Fellman, we represent Lincare Holdings. This is an appeal of a judgment notwithstanding the verdict in a case involving a dispute over an employment bonus. After a 4-day trial, the jury found that Sharon Ford did not prove that she was eligible for the bonus because Lincare had a long-standing and known policy that employees had to remain employed until the bonus was paid in order to collect it, and Ford quit her job before that time. A trial court cannot grant a judgment notwithstanding the verdict unless, after viewing the evidence in the light most favorable to the non-movement and resolving all conflicts in favor of the non-movement, it can conclude that there is no evidence to support the jury's verdict. Here, there was evidence, including Ford's own testimony, that supported the jury's verdict. But instead of permitting the verdict to stand, the trial court reweighed that evidence and made its own credibility determinations to set aside. We are asking the court to reverse that judgment notwithstanding the verdict and reinstate the jury's verdict.
So going back to some of the things you just said, that there was evidence by her own statements to support the verdict. And these were the statements she made, that she was aware that when she was in the legal department and not head of the mergers and acquisitions position, that a condition of employment was a company policy for anyone to get a bonus that had been otherwise be awarded. And that's the whole issue in this case. You know, she left before the bonus was to be awarded. Therefore, Lincare took the position that she's not entitled to the bonus. And her position was that was a company-wide policy that did not apply to me. Is that correct?
Correct.
Okay.
That is correct. So there was testimony that this was it wasn't actually a company-wide policy. So let me clarify that. This was the policy applied to all corporate headquarter employees, sort of the administrative part of Lincare. And the evidence was that the policy had repeatedly, year after year, been enacted and implemented through this resolution process. And so at trial, when Ford was presented with the current iteration of that resolution, she said, well, I knew, and I'm going to quote here, I know this is how it was done when I was in the legal department. The board would allocate from a pool that was handed out for bonuses to each department. And she admitted that, quote, if you're not there, you're not getting it. She also admitted that since then, she knew that all bonuses for corporate headquarters were paid at the same time, whether they were calculated or discretionary. And that, of course, then jived with the testimony of the Lincare executives that this was a longstanding policy, was nothing new.
But the tough part about her position is that she had a bonus that was unique to most of the other employees. She shared with the executive team only, I think, the fact that she had a performance-based bonus, a formula that determined her bonus. Everybody else's bonuses were strictly discretionary. At the end of the year, you know, the executive team got together and they awarded bonuses just based on feel-good things, you know, and there's no real formula for it. And so Ford's position, of course, was because I have this specific bonus, I have a specific employment agreement that basically spells out my bonus, which is remarkably devoid of any mention of this policy that you have to be employed to get the bonus. So you know, so, I mean, the position is that this company-wide policy was by implication applied to her, even though in the face of her contract, it was not spelled out, right?
Correct. Her contract called for a bonus. Okay, it's the email, the 9-line email said, we're agreeing to a bonus. And the bonus was as a formula, and there was some testimony that was a bit unique. But again, she was aware of the policy. She was aware that after this, that up until and past the time of the April 2014 email, all bonuses were paid at the same time. They were all paid in the next quarter. And so what she was asking the jury to believe, based on her uncorroborated testimony, was that she just didn't think it applied to her because she's unique, because she had the email. But that was, again, it was a credibility question for the jury in light of the evidence that it did apply to her. And I want to point specifically to the CFO's testimony, because the CFO, Teufel, he had joined Lincare in 2013 before this email was entered into between Schabel and Ford. And he testified that in his job as CFO, he oversaw the payment of the bonuses, and that Schabel paid Ford according to the same policy, just like everybody else in the company. And again, Ford admitted all those bonuses were paid at the same time. So the question is, can Ford take the position that she can simply say, herself, uncorroborated, I just didn't think it applied to me, and then exempt herself from a policy that the other witnesses said applied. I mean, this was a great argument for the jury, and the jury rejected it. There was also evidence that she worked every week with the executives who implemented this policy, and so that she had to have known of it. And in fact, it would be shocking for her to not know of it and to think that it didn't apply to her, in light of it applying to all of the corporate headquarter employees.
So she admits to knowing of the policy itself, and what essentially what it comes down to is Lincare is saying it's astounding that it's not astounding that she didn't know the policy, because she admits to knowing about the policy. My words, not theirs, astounding. It's astounding that she didn't know it applied to her. So they've asserted that Lincare could not produce any examples where this policy of not awarding bonuses after an employee has departed has been applied to a non-discretionary bonus. I'm not saying this is positive, but is that true?
There was no testimony. That's correct, Your Honor. There was no testimony, and one way or the other, whether the policy had been applied to any prior employee, there were no examples given by either party. And again, it ultimately, I think this is kind of where the trial court went. Well, the testimony could have been more specific, or nobody called Shable, and but the evidence is what the evidence is, and it went both ways. And if you look at the judge's order, you can see him reweighing the evidence. He's talking about her testimony, and I just want to go through some of these instances in the court's order. At page 4 of his order, at record 1381, he credits Ford's testimony, quotes her testimony, says Ford said this, and the jury of course had rejected that. Then he acknowledges that the Lincare witnesses testified that she knew of the standard company policy of such annual resolutions, but he discounts it. Then he says, well, that lacks specific details. He doesn't say what the details needed to be, and the law doesn't require them. And then on the same page, he states, well, the resolution did not specifically identify Ford, but the undisputed testimony of Teufel was there's a list of all the corporate headquarter employees. It includes Ford. And that's who falls under this bonus policy. And then the court commented that, well, they didn't remind her of the policy during the dispute over her 2016 bonus. But of course, viewed in the light most favorable to Lincare, that's consistent with their testimony. This was a long-standing policy. There was no need to remind her of something. And again, this was, Ford, yes, she was paid under a formula, but she was also somebody who had direct contact with the executives. And the executive said, it'd be shocking. I think it was shocking, astounding, that she didn't know that this policy applied to her. And really, it was her own uncorroborated testimony. It was her burden of proof. And she didn't have anybody else to say that, oh no, yeah, I didn't mean that. I mean, one of the things that you look at is, the trial judge recognized this at some point in the trial. He said, every contract has a context. So here we have a short email, and it calls for a bonus. It's named a bonus, and it's made in the context, the evidence shows, of a bonus policy. And Ford's position is basically that she can come in and testify just by herself that she just didn't think it applied, and then that's it, and game over. But the evidence went both ways on this, and the jury had to make that judgment call. And I want to point out that, when it comes to credibility, there were reasons for the jury to question Ford's credibility. There was first her acknowledgement that she did know of the policy, that she knew it was paid, that every employee, discretionary, non-discretionary, was paid at the same time under the policy, even when she was in mergers and acquisitions. And there was all of that testimony. And then the court actually instructed the jury without objection that in order to understand and decide what the disputed terms of the email contract meant, they needed to consider how parties acted before and after the contract was created. The other thing the judge did in his oral rulings was he displayed that he thought it had a yucky feeling about it. But these are common policies that businesses are allowed to employ in order to incentivize their employees to remain employed. And Florida law has long recognized that they're enforceable, and they present a question of fact for the jury.
Ford has argued that you didn't preserve your implied term defense because you didn't raise it below. You want to respond to that?
I'm going to respond to that in 2 points. The first is that we did preserve it. We argued the same principle of law, that employers are allowed to have these policies, that they are enforceable, and that they present a question of fact at summary judgment, in motions for directed verdict, in response to motions for directed verdict. Ford's argument relies on effectively the fact that we didn't cite more case law, and the judge was concerned that the case law that we did cite in the trial court, had some factual distinguishing features to it. But preservation does not require you to cite all the best cases or all the on-point cases. It requires you to argue the same legal principle. And this was a key feature of the trial, this argument. It's actually the whole genesis for the jury instruction, the jury question on the verdict form that we're talking about. So this was the question presented to the jury based on Lincare's argument that this presents a fact question. So it's fully preserved. I also want to talk about Ford saying it's a defense, because the case law says that this is actually the burden is on Ford in this instance. And so the jury found that she did not meet that burden.
Should we attach any significance to the fact that this 9-line email contract did not have a merger clause?
Yes, I do think you have to attach significance to that. And I think that's what the case law recognizes in this employment context, is that often employment agreements, sometimes they're oral, sometimes they are emails that just agree on compensation, sometimes they are 5-page contracts. When they do not address when a bonus accrues or when any kind of compensation accrues, then you look to the pattern and practice in the business and whether there's an established policy. And so there is no merger clause. It was clear from the testimony that nobody thought this email covered everything. In fact, here's an example from Ford's own testimony. Ford said that the bonus only applied if she closed the deal. It doesn't say that in the email, but she understood that from the party's course and practice. So there's a context, again, like the judge recognized at one point, there's a context to all of this. The policy pre-existed the email, the evidence was clear on that. And when they agreed to compensation that included, quote, a bonus, that term bonus had a meaning at Lincare. It was a bonus according to the corporate headquarter bonus policy.
Is there a distinction in case law that we should recognize between commission and bonus? There was a lot of talk in the briefs about the time at which a bonus or a commission was earned or vested.
I think for the purposes of this argument that the same rule applies to commissions. I mean, that's clear from the cases. And so when we think about commissions, we think about a certain type of incentive-based compensation. And so the fact that it would apply to commissions would suggest it applies equally to any type of compensation, whether calculated or not calculated, discretionary. It all comes back to what the policy is on when compensation accrues. So I think for our purposes, we in our brief, we interchangeably, incentive-based compensation or formula-based compensation, commissions. There's not a lot of change in terms, and it typically comes up in the context of commissions.
Well, as it specifically relates to this case and the facts, am I correct in recalling, I may not be, but that there were other employees who received commission on a less than yearly basis, perhaps the salespeople?
That's correct. So there was testimony that salespeople at Lincare were compensated on a totally different arrangement, as a separate segment of the company, and that they would not have received a 6-figure salary like Ford did, and they would have been paid commissions on a more regular basis as a result. And also that they too had certain parameters that they had to meet. It wasn't just to make the sale, it was to make certain levels, it was to get paperwork in, things like this. So again, they had a contract or agreements, and they were subject to policies that they had to abide by in order to, in order for the commission or the bonus or whatever you want to call it to accrue.
Ms. Norris, you're right at 15 minutes, but it's your time. Do whatever you want to with it.
The question presented at trial really came down to an issue of disputed fact and credibility. The jury resolved that question in favor of Lincare, and the evidence supported that. And the trial judge could not take the consideration and reweigh the evidence and credibility and substitute its view for the jury. So we'd ask the court to set aside the judgment notwithstanding the verdict and reinstate the jury's verdict. Thank you.
Mr. Donovan?
Yes, may it please the court. My name is Chris Donovan. I'm here on behalf of the appellee, Sharon Ford. This court should affirm for 3 reasons. First, the arguments on appeal are not preserved. Second, there is not a general exception to contracts such as to general employment contracts, recognizing that going against the basic contract principles and this court's Padwary decision that says that employers must continue to pay their employees for compensation earned prior to
doesn't it come down to when it was earned, at what point it was earned? And if we accept your premise that case law requires that employees continue to be compensated for benefits they earned, doesn't it come down to whether it was earned or not?
It does, but in this case, going to that second issue, Your Honor, this case is actually a basic contract principle case. There was a written contract that expressly provided 2 things regarding this the contract related to the compensation. And in fact, the actual exhibit, plaintiff's exhibit 1, in the first page of it, her boss said, these should be the terms of your full-time employment. And those terms provided for 2 things. 1, a non-discretionary bonus that would be calculated based on 1.85 pro forma revenue. If there's no closing, then they can't calculate 1.85 performance revenue. So even though they don't use the word closing, it's certainly, it couldn't be calculated but for 1.85 pro forma revenue happening. And the second condition that it provided was that they would be paid annually. Those were the only terms provided for in the contract, and those so in order for her to earn that, all she had to do was to close things, and if she didn't close them, then she didn't get paid. So she had completed all of the necessary requirements, all of the conditions in her express contract for obtaining her payment, and there's no condition providing for prohibiting post-termination payment. In fact, the employment contracts are no different than any other contract. In fact, this court just recognized in the last case that courts can't rewrite bad bargains for the parties. Parties cannot unilaterally alter their agreement. The contract silence suggests generally an intent not to include terms, especially when her COO is saying, here are the terms of your agreement, and they don't mention anything about a forfeiture policy.
Sorry to interrupt you, but I understand that case law, and you're extolling it well. But I was just curious. So if we were to reverse, we would be saying that a company cannot have a company-wide policy, and then regarding a prohibition on bonuses paid to those who've already left the company, and then have a specific bonus structure for each individual over which that company-wide policy is laid. Right?
I think that's correct, Your Honor. I mean, they could have a policy, but if it's never been brought up during the terms of the negotiation, which looking at the emails going back and forth that led to Plaintiff's Exhibit 1, there was never any mention of this. There certainly was no.
But isn't Mr. Donovan, again, I'm sorry to interrupt. I hate to do that, but I have to. As you know, we only have a little time. But isn't the issue here that the jury heard all this evidence and came to a decision, and there was evidence to support their decision, even though you don't agree with it or like it? Isn't that really the issue here?
Respectfully, no, Your Honor, because the jury can't make a decision based on facts that the law doesn't provide. And the law provides, in fact, it probably should have never gone to the jury because it's a contract. And you just simply look at the supremacy of the text controls. Look at the plain language of the text and apply it. That's essentially consistent with this court's Patwary decision in Abbott, which basically says that an employee is legally entitled to the compensation that and other benefits they earn. In fact, under the Supreme Court's Knudsen decision, that's the contract, that's the method of calculating damages, is what did they earn while the contract was still in power. So to go back to your Honor's question, Judge
Isn't there
Atkinson,
a recognized exception to that? Doesn't the
There are-
law yeah, talk
sorry.
about that.
Yes, sir. Yeah, there are really only two exceptions. The first exception is when the contract expressly provides that that the bonuses and commissions cease upon termination. And the second exception is when they're service-based contracts, or what the law says is when the performance of the contract is part of the services of the performance are the entirety of the contract. In other words, an employer who gives you accounts and says, work the accounts. I mean, obviously you wouldn't, your compensation is based on the earning, continuing to serve those accounts. The next guy who comes in isn't going to be do them for free. So the exception makes sense in that context, and it's consistent with the general principles. Lincare, however, wants to rely on two decisions, one from the 3rd DCA and the other one from the 5th DCA. And respectively, these do not really create a third exception. The Cornell decision from the 3rd DCA just simply almost indictive, because they ultimately applied the general rule in Abbott and Padwary. They said, well, when there's proof of an industry custom, then that right of payment ceases. And then from that, Comerford, the 5th DCA case, expands on it and states, towards the end of it, states the company, if the company has an established policy communicated to its employees precluding post-termination payment, then the policy becomes an implied term. They cite nothing to support that statement except to rely on Cornell's industry practice evidence. But they, of course, acknowledge, this is Comerford, acknowledges that it can't override the express terms of the party's contract, which here there's an express terms of the party's contract.
There's an express term of the party's contract that says you have to get your bonus after you've left the company?
No, there's not an express term that says that, but there's an express term that says she's entitled to non-discretionary bonuses based on the how it's calculated.
And is there a merger clause in that contract? Contract basically provides that if it's not contained in this language, then it ain't part of the deal.
There's not a merger clause, but respectfully, there was no evidence that at the time of the creation of this contract that this policy existed. The only two people that—
Wait a minute, there was no evidence that this policy existed at the time of the creation of the contract?
Correct, Your Honor. The only two people who presented evidence were hired in 2013, almost 12 years before this contract was created. And they simply said, well,
but the contract, when she came back to work, when did she come back to work?
In 2013. I'm sorry, you're right. I see what your point is. I misspoke there. The contract was created in 2013, but the parties who were involved with this were not the people who drafted the agreement. Miss Hofer and Mr. Teufel expressly stated that they had no ability to speak on the specific terms of her agreement or what was discussed during the negotiations. Nor did they really present any evidence that there was an actual policy. And I think we're using this term quite flexibly.
Well, there was some evidence, whether you find it persuasive or not, or whether you find it to be weighty evidence, there was some evidence that this policy existed, including statements by your client that when she worked in the legal department, she was aware of this policy. If you weren't working at the time the bonus was paid, you didn't get it. And that's obviously the struggle you have in this case, because there is evidence that there was a policy. It apparently applied to everybody, including people in the executive council. But your client's position is applied to everybody except me. The jury heard all this testimony, and the jury rendered a verdict that no, it applied to her, and you don't get a bonus because you weren't working the day it was paid. And so the difficulty we have here, all these interesting arguments about whether it does or does not happen. It's really a question of was there evidence to support the jury's verdict? And that's the hard thing about what Judge Huey did, because there appears to be some evidence, whether you like it or not, to support the verdict.
Respectfully, Your Honor, I believe that that Lincare is taking Ms. Ford's statements way out of context. She did not admit to knowing that there was a forfeiture policy. She did not. In fact, she said she had never seen it until trial. She would, in the testimony that you're speaking on, and I'm talking about transcript pages 423 through 426. She specifically states, when I was a discretionary bonus employee in 2001, this is where I was referring earlier, 14 years prior, I understood that there was a pool of money that was divvied up between departments. That was the policy that she understood, that there was a pool of money for discretionary bonus employees that was divvied up by department heads, and she happened to get one.
But Ms. Hofer, the CEO, basically said, this policy exists and it'd be unthinkable that she couldn't possibly know it because it was so widely understood. And so the bottom line is the jury heard that testimony. They weighed the credibility of your client's denial, and they didn't find in her favor on this issue. And jury, as you know, a big deal of what a jury does is weighs the credibility of all the witnesses and has a right to believe or disbelieve all or any part of the evidence and testimony rendered by a witness. And in this case, they didn't find your witness credible on this, or your client credible on this issue. I mean, and that's the struggle here. I mean, so it's, I have a hard time seeing that there is no evidence to support their verdict. There is some evidence.
I think, again, if you're looking at Ms. Hofer's testimony, she's not specifying there was a forfeiture policy. She's simply going back onto Mr. Teufel's statement that this is how we did things. We divided up into a pool of money and delved it out.
But even without that, I hate to, isn't it a he said, she said, or she said, she said? I mean, even if we don't perceive of that testimony and the way that Lincare is advancing it, which is an admission that there was an acknowledgement on our part that this policy exists as some employees, aren't we looking at the reweighing of the evidence on both sides by the trial court?
Respectfully, no, because the jury could not defeat the express terms of the contract. The jury could not defeat Florida law.
But the express terms contract didn't specifically exclude this policy. It didn't have a merger clause, which basically said this is the totality of our agreement. So presumptively, this policy that everyone, that was applied to every single employee of Lincare who was qualified for a bonus, Ms. Ford says, applied to all them, but not me. Everybody knew about it, but I didn't.
Respectfully, Your Honor, Florida law provides, this is the Padaway decision, provides that if you earned it when you were there, then you're supposed to be paid it. That the Supreme Court's 1934 Knutson case said that is the damage. That's the damages for breaching an at-will contract, is that you get paid what you've earned.
So you're telling me that an employer can't craft an employment agreement that specifically says if you're not here when the bonuses are paid, you don't get it. You say that the Pathway decision basically says you can't do that.
Not unless it's an express term of the contract, Your Honor.
Okay.
I don't believe that's what the case law supports.
Was there a term in the contract that said when the bonus would be paid or how frequently?
It said it would be paid annually.
Okay.
Which logically has to be paid annually because you can't know how much a given year's closing, how many closings are going to happen in a given year until it's happened, until all the
closings. Did it say on the calendar year, on the business year, did it say January 1 to December 31st?
No, it just said annually.
Right.
It didn't say.
How do you know? How do they know when to gauge the year?
I mean, I would say based on pure logic that if it doesn't say annually, it presumes a calendar
Was there a
year,
policy? Was there a company policy that was imposed on a contract of this type to measure the year from just January 1 to December 31st?
No, Your Honor, but on the flip side, looking just at this policy, I don't think this policy that we only have a written version of it in 2015 and 16. It doesn't specifically refer to non-discretionary bonus employees.
What if a employee left in November? Was there something in this contract that required that the person receive a prorated share of the commissions for the year? Or?
No, but under Padway, she would be, the person left in November, she would be entitled to all closings up to November that had occurred, because that was a part of her compensation. That was no different than her base salary, really. It was together with it. In some respects, calling this a bonus is not entirely accurate.
You just said you had to wait till the end of the year to know how many to calculate it.
Only because
you said that's why it was logical that it had to be from January 1 to December 31st.
Well, if she's left in November, there's not going to be any further closings by her. So the logic is still sound, because she's left in November. They can just go back and look at how many closings she had and then calculate the pro forma amount. Without knowing how many closings there's been, they can't fully calculate the pro forma amount. If you'll permit me, I do think, however, there's also an extra problem here, and that's this preservation. The arguments that are being argued on appeal are drastically different than what was argued at the trial court level. In fact, the Lincare wants to highlight that the judge felt yucky about this policy, but he felt yucky because they never connected the legal dots, showing that, well, if there is a policy and it's communicated, then this becomes an implied term. And this was a judge who.
But Mr. Donovan, I mean, maybe they didn't use the words implied term, but it was certainly in the context of this argument that these issues were raised. I mean, the whole issue was whether or not this term, it did not appear in this employment contract, was part of Ford's deal. Now, you call it whatever you want, put all the labels on it you want, but all the arguments within that framework certainly were made below. I mean, yes, maybe they're more fully developed now, but the issues were raised and they were addressed and they were ruled on.
Well, respectfully, Your Honor, if a trial judge is repeatedly asking at summary judgment, at trial, and during the DV or the directed verdict hearings, and at the JNOV, do you have any cases, any law that would allow me to contradict basic contract law that says I go with what's in writing? Do you have any other cases besides this Southern District Rionda case, which is clearly distinguishable? And the cases in the Lincare's trial attorneys say, no, Your Honor, that's it. It's just a factual decision, but it's not a factual decision without the cases that they are now arguing, without the legal theory that it's an implied term. It's not a factual decision.
Well, what if someone voluntarily terminated their employment in August and said, I'd like to be paid on the fiscal year. I want to be paid on the fiscal year, and I want it now.
Even if that was the case, it would still only be the closings that happened during the.
But wouldn't we look to something outside the four corners of the nine line contract to determine how it's calculated, when it's paid?
Even if you would, an employee who has a contract, it's just not reasonable to say that an employee who has a contract of how she's supposed to get paid a bonus would then think that there's a forfeiture clause, that if she's not there because they're saying we're not going to pay you this bonus, we're not going to pay you this. So she leaves or feels constructively evicted, or excuse me, not evicted, but terminated, which is what the evidence bore. The Lincare wants to argue that she abandoned her job, but they said, hey, we're not paying you this. We're not giving you this $500,000 or $1 million if you count both things. So that's the only reason she left. And now they're saying that, oh, well, we have this policy that says that if you're not here, you can't get that. You can't get damages for us breaching because you're not here. I don't think that's a reasonable inference, and I don't believe that there's evidence that says that she knew about the precise forfeiture policy, that if she's not here, then she will not get paid. In fact, there's no evidence that this has ever been enforced on anybody, much less a person who has a contract that says if I work hard, and I close these deals, then I'm going to get paid. And then when,
Well,
the
it's never been enforced on anybody because no one in the history of Lincare has ever laid claim to $1 million bonus, let alone a $500,000 one. And the $230,000 one she was offered far exceeded any amount she'd ever made while she was there. And so I can imagine that it's never happened at Lincare before because this factual scenario is unusual.
I don't know that it's, I know that the numbers are large, but I don't know that the factual scenario is that unusual. They could have at least presented evidence of commission-based individuals who left or whatnot.
It'd be hard
Was there any
pressed for me
evidence?
to
Was there
think
any
of
evidence?
this- You know, go
Go
ahead.
ahead, Judge.
You saved me from myself, Judge Atkinson. Go ahead.
Sure. Okay. Is there any evidence of individuals who have left and were not employed at the time the bonus was paid and still received their bonus?
And we're at 20 minutes, just so everybody knows. So please wrap it up quickly, Mr. Donovan.
Sure. There was no evidence as far as I know of that. Therefore, respectfully, Your Honors, I don't believe this argument was preserved. It's certainly drastically different. And now Your Honors are having to wrestle with issues that could have been flushed out below, including whether or not actual knowledge or constructive knowledge, which is the only evidence that exists, would support
We always
this.
struggle with issues that could have been flushed out below in every case.
That's true, Your Honor. But I respectfully request that this court affirm, because under the law as framed to the trial judge, it was the correct decision.
Thank you. Ms. Norris, you have 5 minutes.
Thank you, Your Honors. So I just want to touch on a couple of things. The first is that yes, this was the classic jury question. There was evidence both ways. Some of that was direct evidence from Ford, and then direct evidence from Teufel. That was the CFO who bridged both the bonus policy under Schabel, who paid Ford's bonus per the email and paid it under the same policy. And then he was there when the 2014 email was negotiated. He wasn't part of it, but he knew how Schabel acted both before and after it. I want to point out that the jury had another key fact that they could look at in thinking that maybe Ford knew more than she said, in that when she was having this dispute on January 27th with Hoifer about her bonus, and they weren't going to pay her what she demanded, she tried to recast it as a constructive discharge, or you're firing me or you're terminating me. And so the jury saw that also, which again lent credence to Lincare's view of the evidence. You know, every Florida District Court of Appeal and the 11th Circuit Court of Appeals has applied the same principle that's stated in Rionda, that recognize that even if you have a written agreement, if it's silent as to when a bonus or a commission or other type of compensation accrues, then we have to look at whether or not there's a standing and established policy that was communicated to employees. So there was really no question in the trial court that this principle was a wacky principle and just didn't apply. It was whether or not it was distinguishable, whether or not Rionda was distinguishable on its facts. And exactly right, preservation doesn't require us to cite every case. And simply saying that the bonus was earned and then calling this a forfeiture, it's just trying to forego the analysis, because what the cases consistently say is you don't have in the contract or in your oral agreement, when a bonus or a commission or compensation accrues, then we have to look to the pattern and practice. And again, the jury was specifically instructed on this without objection to look at the context in which this email was created. On preservation, I just want to touch quickly on that. In our reply brief, we pointed in the 7 cases in which we argued the same principle of law. That's what the law requires. I would note that the trial court not only asked Lincare, but also asked Ford, have you found anything closer on point? And then he admitted that he had his own law clerk looking at the issue to see if he could find anything on point. So this is something where additional cases were caught on appeal. I suppose that's a nice advertisement for appellate attorneys. But the legal issue was exactly what was presented before. It was a feature of the trial. The judge initially saw it correctly, sent it to the jury, but then he just took it back, reweighed the evidence. His order shows at least 5 instances of kind of discounting some testimony, crediting others, and ignoring others. And that is the improper on a judgment, motion for judgment notwithstanding the verdict. The jury's verdict should be reinstated. Thank you.
Thank you very much. Thank you both. Well argued. Our next case is Zinke versus Hillsborough County. Okay, looks like we're all here. Mr. Warren, I think you're up. Do you want to reserve 5 minutes?
5 minutes, Judge.
Okay, please proceed.
Good morning. May it please the court. My name is Michael Warren. I am representing the petitioners in this matter. The material facts are not in dispute. I will very quickly go over some of those and move on to the question before this court. This action stems from a code enforcement case in Hillsborough County. My clients are landowners in Hillsborough County. They reside on a fairly secluded residential property on several acres. It is in a more rural part of the county. They have had a run-in with local code enforcement on several occasions. They were initially cited in 2016 for having debris and trash on their property. That case was pulled by code enforcement. It was dismissed by code enforcement. And the transcript in the record from the November of 2017 code enforcement hearing makes clear why code enforcement essentially said, we think that we trespass on the property, so we're going to pull that case. They then go back out to the property. This time they used an easement that runs through the back of my client's land. And they gathered all the evidence needed for the code enforcement investigation from the vantage point of this easement. They file an action. It goes in front of code enforcement. My clients appear. My clients make a nearly entirely legal argument to the code enforcement board. As I'm sure this court's aware, code enforcement boards are often chaired and filled with unelected non-lawyers. No comment on that, other than to say that these legal arguments didn't go over very well. My clients were talking about the Fourth Amendment. They brought.
So what is that issue here is whether you get to appeal the arguments that you said didn't go over too well. So I was looking at the statute, and I want to ask you something about it. The statute says that an order of the type that was entered after the first hearing can be recorded. And if it's complied with by a certain date, then the board issues an order acknowledging compliance and records that. So we had an order that in the statute says the findings therein shall be binding on the violator. This is prior to this question about whether they come into compliance. So a finding that they are out of compliance can actually be recorded. And you're telling me that that was not a final order and for which the 30-day appeal time ran?
No, I'm saying that that was a final order. But I'm making two arguments to this court. Number one, I'm making the argument that the subsequent final order on the compliance issue is and was presented to the circuit court as a plenary appeal.
If that was an appeal from that, but we're not talking about your client wanting to appeal whether he came into compliance. We're talking about your client wanting to appeal whether he was ever out of compliance.
Well, it seems like the big issue here is whether or not the evidence was lawfully gathered with which the code enforcement violation was issued. And it seems like that's what Mr. Warren's clients want to challenge more than anything. The difficulty is that once the order was entered by the hearing officer that they were not in compliance, there's a 30-day time period which ran and a notice of appeal was not filed. There was a subsequent hearing that purported to adopt the first order, which is the position they take, which caused the 30 days to run from the subsequent order because it adopted the first order. Mr. Warren, am I close?
That's absolutely correct. And well, there's really two ways to get to where my clients want to be. And one way would be to convince this court that appeals of this nature that are taken of the subsequent hearing that Judge Atkinson spoke of that are about noncompliance, but appeals taken from those, are they plenary appeals? If they're plenary appeals, then everything before the final order is subject to appellate review. There is a 13th Circuit case in Hillsborough County that's cited in the briefs, wherein right here in Tampa, where this case was held, there's precedent at the local level that these are plenary appeals. And that case
Well,
is,
I understand that point in the context of a final judgment, and a plenary appeal can be taken in which previously entered orders in that case that ended in a final judgment that was appealed can be addressed because the appeal is plenary. But here we have a final judgment, and actually the statute and the final judgment contemplates that that the fine could be avoided, which has already been imposed, could be avoided by bringing it into compliance. And the statute breaks that out as a separate matter. In other words, there's a final order that is recorded, and then, yeah, if you want to bring it into compliance and avoid a fine and avoid the cloud on your title, then yeah, then the agency is required to file an order that record an order that is in compliance. So is there not a distinction between what you're talking about the plenary appeal in which the appellate court can reach previously made rulings, and this, which is a subsequent order? In other words, the subsequent order only adjudicated whether it was brought back into compliance, not
that's correct,
whether it was ever out of compliance.
That's absolutely correct. And reasonable arguments can be made on both sides of that issue. And that is why in my brief, I cited to the local Hillsborough case, which very confidently declared this was a obvious issue and that this was clearly a plenary appeal. I said, but C, and I cited a case that is C-Truck, Portis v. C-Truck, I believe. I think that, that question is governed by Florida Rule of Appellate Procedure 9110, scope of review. And, the question is, it says multiple final orders may be reviewed by a single notice. But the key is, it says the court may review any ruling or matter occurring before the filing of the notice. And so there is opportunity, should this court entertain it, to articulate a published opinion wherein all code enforcement cases are plenary appeals. And I obviously, you've read the introduction of my petition. I feel strongly that that's a very good idea. It increases access to justice in Florida, because my client was in a very similar position than a lot of other folks. He had
Mr. Warren, the argument that you seem to focus on, though, is that until a fine is actually imposed, there's no reason for any citizen to want to appeal the decision finding a violation. Did I understand your argument correctly?
That was one of the arguments in the brief. I've tried to distinguish.
Well, but in your particular case, the fine seems to be irrelevant to your client's position. Your client's position is they were unlawfully in a place that allowed them to see into my property and gather evidence with which to charge me. It wasn't about the fine. The fine had nothing to do with it. In your client's situation, they were angry and felt violated because these people were on this easement that's only available for horses and people who are doing drainage work. And obviously the code enforcement officers clearly weren't riding horses and they weren't doing drainage work. So the amount of the fine, the levy or the imposition of a fine did not seem to drive your client's disagreement with Hillsborough County.
I would argue that it did, and that's a very practical motivator for all Floridians. I mean, how many Floridians are going to file an expensive appeal over the imposition of a $0 fine? There are some. Some.
If some people feel that their privacy rights were violated and that people were unlawfully in a place that allowed them to peer into their personal space, into the curtilage around their home, that would be a big motivator for some people.
A motivator.
And that seems
what about
like
those who disagree with the finding that they were out of compliance, and they say, you know what, I think I should be able to, I like my grass 2 feet tall, or I don't know, I'm not saying that was the violation here, and Wouldn't that be a reason to appeal from the initial order?
That would be a reason to appeal from the subsequent order. It always comes afterwards. You know, it starts off as are you guilty, and then it goes, did you comply?
So you're
with
saying
our order?
someone who wanted to contest that they were out of compliance should wait until a fine is imposed to contest that they were out of compliance?
At that stage, Judge, they would already have a fine. So at the first hearing, it's
No, but why would they already have a fine? Aren't you acknowledging that this board has the ability to suspend the fine contingent on bringing it into compliance?
That's my point. I think
someone wanted their grass a certain height, said it's not out of compliance, and you're saying they have to wait until the court and the board suspended the fine until such time as they brought it into compliance within a certain time period, that they shouldn't file an appeal if they think their grass is in compliance. They should wait until they don't bring it into compliance, have the fine actually imposed, and then they should file appeal.
What I'm suggesting is that the average Floridian, if they don't have a consequence, a monetary consequence to their growing the grass too high, parking the car
The
in the front
consequence
yard,
is, in the order, it said in 60 days, if you don't cut your grass, there's a fine. So you're saying that's not a consequence? The sword of Damocles that will inevitably fall 60 days later when the code inspector comes out and your grass isn't cut, that's not a consequence?
I think it is a consequence, Judge.
So then why wouldn't an aggrieved homeowner file within the 30 days after the order that found the home out of compliance?
Because the average Floridian is middle class and they can't afford to spend thousands of dollars in legal services when all they have to do is convince, and they don't want to fight City Hall anyway, Judge. I mean, these are tough cases. So why would you file an expensive appeal over a $0 fine when instead you can just—
It's not a $0 fine. It's not a $0 fine. They said I just said, I'm not making up a hypothetical. This is your case. It said in 60 days or however many days, if you don't cut your grass, it's hypothetical as to the facts I'm saying now, but the suspension of the fine is not hypothetical. That's the facts of your case. You will get fined. How is that? How you're characterizing it as appealing something that has no fine imposed? There's a fine imposed. It's just a grace period.
Correct. And it's the weakest argument that the petitioners have. And so I'd like to move on to some of my stronger points, but yet that is essentially what I'm arguing, that people, they'll try to bring it back into compliance themselves instead of filing the appeal. But I agree that it is a consequence.
3 minutes, Mr. Warren. So why don't you move to your stronger arguments?
I'm sorry, where was I, Judge?
You're at 12 minutes and 23 seconds. And so if you've got stronger arguments, it'll be time to make them.
Perfect. So regardless of that, if this is a plenary appeal, then the court erred and departed from the requirements of the law by dismissing an appeal with jurisdiction. So if this is a plenary appeal, then that subsequent order the previous order was part of the appeal. Alternatively, if this court is not willing to say that these code enforcement cases result in plenary appeals, in this particular case, the government, the local code enforcement, allowed my client to relitigate this legality issue and then specifically enacted a final order that was appealed, where a notice of appeal was filed within 30 days thereof. And in that piece of paper, it said that the order specifically readopted the first order. And so
what should we make then of a non-lawyer hearing officer putting language like that in an order, which maybe has some legal impact, maybe it doesn't, with us understanding that he probably doesn't understand the legal impact of that language in terms of the jurisdiction to appeal, appellate rights, for example?
Well, I think that, there are a lot of cases out there that say that when there's some ambiguity in, appellate rules or procedures, that ambiguity is to be determined in favor of the appellant because we want access to the courts. But I would say that I think that everybody was on the same page. Everybody in this case probably thought that the board, number one, has the lawful ability to do that because in their own rules, it says that they do. It says that they have the ability to modify and vacate and change their orders. And I think that the county was on the same page as myself and my clients because this issue was fully briefed in the circuit court. and the issue of jurisdiction was not brought up. And I think it's because there's a piece of paper that says that the final order republished the first one. And so if this court believes that quasi-judicial boards have the authority to republish their own final orders, then this court needs to determine whether, in this case, that actually occurred. I think we're stuck with the language in the final order, but a plain reading of that language and applying the dictionary to the word republish, I think will allow this court to grant my client appellate rights. And I'll go ahead and, unless there's a question, I'll reserve the rest of my time.
You're right at 15 minutes. You're perfect. Your timing is excellent. Okay. So let's hear from Mr. Pope. Mr. Pope?
Sorry, Your Honor. Ken Pope with Hillsborough County on behalf of the county. Judge, our position is that the circuit court did not depart from the essential requirements of the law when it affirmed the special magistrate's order of violation because petitioner failed to file a notice of appeal within 30 days of the special magistrate's order imposing fine dated November 20th, 2017. Now, our process may be unique to other counties in that in addition to appearing before the code board, there's also the procedural rules of the Hillsborough County Code Board. And it offers two opportunities to go back before the board. One is the contest, and then the other is a rehearing. Under the contest, which is the situation in this case, the only question is are you contesting the notice of violation that was filed by the code enforcement officers? And it has to be done within 10 days of the order imposing fine. And at that time, they're not relitigating the case. It's, the other is a rehearing that's actually a de novo hearing. At the rehearing.
Could you take an appeal? Sorry to interrupt you, but I do know what you're talking about. Could you take an appeal from a contest? In other words, let's say, taking your position for the sake of discussion, which is that initial finding of being out of compliance is done and gone and 30 days has passed, but could an appeal be taken from the hearing, the contest hearing, as you all described it, and for the purpose of appealing the finding that the property had not been brought into compliance?
Yes, Your Honor.
You could do that. So my question is this: so you could do that, and your position is that 30 days had already run on the initial order, which was not the contest hearing, but it was the finding that it was out of compliance to begin with. My question is this: even acknowledging the rules you've stated support your position, could not the board determine that they sua sponte wanted to rehear the initial finding of being out of compliance and then readopt or have a new order from which appeal could be taken, notwithstanding the rules you're talking about?
Judge, that's not the case here. If you're asking if they could sua sponte decide they're going to go back and rehear some of the matters that they heard previously and in the original hearing, those aren't the facts here. Could they do it hypothetically?
Counsel, I think one of their arguments, he'll correct me if I'm wrong, is that even acknowledging everything you've just said, what the board, the adjudicatory board did was readopt after reconsidering.
Your Honor, I would actually agree with Judge Morris when he characterized the board as it's a lay person. And in fact, I think in petitioner's brief, they point out the fact that he's a realtor. So these are people who are volunteers. The code officer.
Right, so both counsel for the appellant and the appellee we know that they're not lawyers. My question is a matter of concept. Well, whether the individual is a lawyer or not, enter a new order or readopt the order that had initially found the property out of compliance. After considering, for instance, the evidentiary issue of whether the evidence should be excluded because they were trespassing the easement.
Judge, whether it could or whether it couldn't, our argument is that he did not. We agree with what how George Morris characterized it as, I would say, inartful. The way he used the term adopt, it may mean something in our world that's different from a layperson's world. If he used the word affirm, I think we wouldn't even be having this particular argument right here. And you will notice that if you review that the May 16th order, that he refers back to February 11th, and that's the date at which he gave the petitioner to bring his property into compliance. The purpose of that, I think at the original hearing, the one on November 13th, is when he asked the petitioner, how much time do you need to bring your property into compliance? He said 90 days. So he gives him 90 days. Now, whether or not he gave him 90 days or 60 days or 30 days, he still found him to be in violation. The only benefit he would get to having 90 days is to comply the property and then not have the fines run. Because as you pointed out, once the county files the order, or it becomes a lien on the property. And then the rule actually gives the county 90 days after that to actually file foreclosures or to seek money judgments. So the benefit that he would have gotten with the more time would just be to help himself not have to pay a fine. But it's important to point out that he was still found in violation, and the statute also allows people to be designated repeat offenders. The difference is basically the maximum on a first offense is $250. On a repeat offender, it could be up to $500, and that's per day. So that's the benefit of getting that extra time.
Mr. Pope, help me with the timing a little bit. So the original order was rendered on what day?
The original order is November 20th, 2017.
And then the subsequent order was rendered on what day?
May 16th, 2018.
Okay, so it's well past the 30-day time frame to appeal the first order, correct?
That's correct.
So if I were to make an argument that it's unfortunate that the hearing officer used careless language to confuse people about when they should or should not appeal, even that argument is irrelevant here, because under any scenario, the time would have run. Is that right?
Well, that's correct. That's correct, Your Honor, because
Okay.
at the bottom of the order, it cites to the statute 162, which gives you 30 days, which is also the same as 9.011, I think, of the Florida Rules of Appellate Procedure, gives you 30 days to file your appeal. Now, at the bottom of the contest, at the order denying contest, also gives you 30 days, going back to Judge Atkins' questions, whether or not they could appeal both orders. And the answer to that is yes. The difference would be, and that's really the purpose of why we're here now, is when Judge Stoddard, the circuit court, got the appeal, he noticed that it didn't reference anything about compliance. It basically wanted to go back and relitigate that issue. He makes kind of a quasi-criminal law exclusionary rule argument that the county was in a place that didn't have an opportunity, that didn't have a right to be, so it shouldn't have gathered that information. So when Judge Stoddard saw that, they weren't complying with that contest language that says you have to talk about whether or not you were in compliance, disregarding the notice of violation. So based on that is when that was in his order to show cause. And then subsequently, they didn't make any other showing other than the fact that they were trying to relitigate that exclusionary rule argument once again. So that's when he said that the court had no jurisdiction.
I have to tell you that in all my years of doing this, it's the first time I've seen a search and seizure argument in a civil context. But it seems to apply here. It seems, but I've just never seen it in a civil context. Have you?
Judge, I will tell you that code enforcement is bound by the Fourth Amendment. So whenever code enforcement is gathering evidence, it has to be in a public place. So in other words, it has to be in a public right of way, or it has to have the permission of the homeowner or of a neighbor. So in this case, we had the permission of the homeowners association and also of neighbors. Now, as you may imagine, these things crop up. This is a secluded piece of property. Code enforcement becomes aware of this because somebody complained about it. And that somebody is the one who basically says, you can stand on my yard and you can take pictures or whatever you need to do. So I really don't think that the permission is as big an argument as the petitioner makes it out to be. But I do agree with you also that probably having that issue aired before a special magistrate, a non-lawyer, is probably not the best forum for that, because I don't, just like you said, they don't probably see that very often.
Thank you.
Judge, I've also cited other cases that I sent afterwards that talk about the 30 days, and that there really is no good reason to go past the 30 days, because courts have generally said that it's a hard and fast rule, that once you go past 30 days, that you really can't, there's no more jurisdiction for the court. I'm citing specifically City of Plantation versus Vermouth, which has a holding that matters determined in an order which hearing became final without appeal are not later subject to appellate review simply because a later order affected those matters or applied them into interlocutory matters under consideration. So in this case, you could say that the second hearing, the contest, is kind of interlocutory, but nevertheless, according to City of Plantation, that still doesn't move the timetable. It sounds to me as if petitioner is trying to merge those two hearings, the two orders, so that it moves up the time frame. They're separate and distinct. 30 days on the order imposing fine is separate from the time on the order denying contest. I've cited other cases as well. Counsel, and I believe it was in his initial brief, cited to the Burkett versus Sharp case, which is out of the second DCA. Now, that case is distinguishable from this case in that there is a rule that the order had to be filed before the 30 days began to run. And for that reason, they filed their appeal after 30 days within the time that it was filed, but not 30 days from when the order was originally issued. This is not the case in our facts. After the November 20th original order, that's when their time to file their notice of appeal had run. Now, one thing that they could do, and I've seen some people do this, is you could file your notice of appeal and not even pay the money. And then you could basically see where you go in the contest, because it's been my experience that the court is very liberal about giving people an opportunity to pay up. You can also apply for what's known as indigency status. So if you can't pay, I think it's $300, then you could apply to be an indigent litigant, and they would waive that fee for you. So Mr. Warren talks a lot about how it's not really feasible for Floridians to undertake an appeal, but in fact it is, and the court recognizes that not all litigants have that money at their disposal. So there are provisions for that as well. Judge, if I have answered all of your questions, I really don't have anything further, and I'll cede the rest of my time to Mr. Warren.
Thank you, Mr. Pope. Mr. Warren, you have just right at 5 minutes.
Thank you, judges, and thank you for your attention. I want to start with something that Judge Morris stated. Judge Morris, you stated that even if the code enforcement officer, presiding officer, was inartful, that so much time had elapsed between the first hearing and the second that it didn't matter, that the time to appeal had lapsed.
Well, my worry is that a non-lawyer hearing officer will use terms that they don't realize the legal impact and confuse citizens about their rights. And that was my concern. So if this had fallen, within the 30-day window after the first hearing, it presumptively would have misled your client into thinking, well, the 30 days, I don't have to file within 30 days of the first order. I've now got this new time frame. Well, yeah, but this totally fell outside of that first 30 days. So they were either going to appeal that or they weren't, right?
Correct. And the distinction that it's very important to make is if this court believes that lower tribunals can lawfully re-enter final orders, And I think we know that to be true in certain cases at the trial court level. And I think that, there's case law that can be true at the agency level. And
Well,
and I
I'm
think
not
that
absolutely certain that's true. Isn't there, and it's 1.530, 1.540. My more
Correct.
experienced colleagues can tell me if I'm wrong, but there are even limits on a trial court
1540, correct.
doing
Correct.
that.
And so once
You're
we're
saying
there,
that in this administrative context, it's different.
correct. But by the rules of the Hillsborough County Code Enforcement Board, which are attached to the supplemental appendix that the respondent filed, it's clear that they believe they have this authority. And my argument to the court is if they do have the authority, and I'm not aware of any case law to suggest that they don't, if they are professing to have this authority. And by the way, they use this authority all the time. I mean, code enforcement boards constantly reduce fines 90, 95% down to administrative costs. So they're constantly modifying their final orders. And
Well,
so
I was going to think of that. I was thinking of that. And there are situations in which there are modifications, and there are also situations in which an order is where enforcement actions can be brought based on what are final orders from which appeal can no longer be taken. Let's say the marital dissolution. So are we to think that there's a marital dissolution, 30 days is run for appeal, and then there's some sort of enforcement action brought, and the husband or the wife of the aggrieved spouse says, hey, you know what, I think I'm complying, but also I think I want to contest some matter that was happening in the dissolution order.
That would be unlawful. That would be unlawful. Absolutely. And
so what's the distinction? Isn't that what happened here?
It's not, because here's what happened here. It's like the divorce case judge, but the trial court who had jurisdiction of divorce said, I'm not going to enter a supplemental order. I'm going to reissue the divorce decree. And I have that authority to do so. And there's a case cited by myself in the brief, I think it's Diamond Drywall Systems, where I believe it's the Second District Court of Appeals is ordering a lower tribunal. You reissue the final order. And the whole point of that case was we need to give this person access to the courts. They didn't get the final order, so you're going to re-enter it. So you can re-enter orders. So the point is, if they did in fact re-enter the order, and they did use the word re-adopted, and we all proceeded as if there was jurisdiction, then jurisdiction is perfected, because there was a notice of appeal filed within 30 days of an order which re-adopted and republished the prior order. So that's
we would have to agree with you that is what happened. We would have to
Correct.
agree with you that, and I think Judge Morris touched on this, and I won't put words or thoughts in his mouth or head, but what I took from it was this: is that what's difficult for that position you're advancing right now is that is whether your client is what your client was raising at what particular time. You're saying that. Let me ask you this: at the second hearing, do we need to be concerned with how much, whether, or to what extent the issues pertaining to the first finding and the adjudication of being non-compliance were addressed?
It was relitigated. If you look at the transcript from the second hearing, my guy comes up, he says, I want to first say that I contest that I'm not in compliance. He then spends the whole hearing talking about the Fourth Amendment. The representative for the code board gets in it as well, and they get into another argument about the Fourth Amendment. So it was relitigated again. And then the last words of the magistrate, of the chairperson of the board, is, you can take this argument to the circuit court. You can take it to the circuit court.
Well, then that does not confer jurisdiction on the circuit court. But
you're at 5 minutes, Mr. Warren, just so you know, so please wrap it up.
I would argue that it is a per se miscarriage of justice when you take away someone's appellate rights. I think that's what the Burkett court acknowledged. And I think jurisdiction is clear here because they republished the order, which they were allowed to do. And therefore, the circuit court sitting its appellate capacity departed from the essential requirements of law by not finding jurisdiction. And that caused the miscarriage of justice. And I thank you so much for your time and attention.
Thank you both very much. It was a very well argued case.
Thank you, Your Honor.
Our next case is Duhamel versus Duhamel. And forgive me if I've mispronounced that name. Okay, Ms. Harrell, we have you. We're just looking for Ms. Lastly. There she, oh,
Can you see me, Your Honor?
there you, I see you now. Okay,
Thank you. Good morning.
good morning. Would you like to reserve 5 minutes?
Yes, Your Honor, I would. Thank you.
Okay. I'm ready
Morning.
whenever you are.
Thank you. Good morning, Your Honors. My name is Jessie Harrell, the Harrell firm, and I'm here on behalf of the appellant, Ms. Catherine Duhamel. We raised 5 issues in our appeal as to why we think this case needs to be reversed and remanded. I will address these in the order that they were handled in the brief, unless the court has specific questions that you'd like to be sure I can get to within the 15 minutes of the argument. The first grounds that we raise for reversal is that the alimony is not supported by competent substantial evidence. The facts show that the trial court awarded Ms. Duhamel only $2,500 a month in alimony and assigned her the tax liability for that, which brings
Wasn't
her...
the court factoring into this the waste issue? They felt that she had dissipated, the proceeds of the sale of the Nebraska home, and that she had otherwise run up credit cards in her husband's name, ex-husband's name, and done things like that, taken out credit in his name. Don't you think those things factored into it? It appeared to me that they did, but I'm more interested in knowing what you think.
Well, Your Honor, as we argued in the brief, there's not competent substantial evidence to support those findings either. But as you know, the alimony award must be based on need and ability to pay. Now, his ability to pay may have been impacted by the credit card statements, but the trial court found that Ms. Duhamel had a need of $2,500, and even that amount of need was unsupported by the husband's own evidence. If you look at just his evidence alone, he submitted a document that showed she needed over $3,000 a month on which to live. And that amount did not include her health insurance. It did not include electricity, didn't include car insurance. And in the final judgment, the trial court even recognized that she had a need for health insurance. But the award made no recognition of the fact that she needed those amounts. And so the finding on need is unsupported by the competent substantial evidence. The finding as to ability to pay, while Your Honor recognized may have been impacted by the findings of waste, what we see in his own financial affidavit, his most recent financial affidavit, that even when he was paying $3,500 a month in alimony and paying the wife's insurance and paying for the credit cards that the trial court believed were wastefully incurred, he was only running a deficit of $500 a month, giving him every allowable expense, allowing him to continue living at the same standard in which which the parties had enjoyed during the marriage. But just prior to the conclusion of the trial, he testified that he received a raise, which resulted in an additional $300 and some odd a month. And he was no longer having to pay the wife's car insurance or her health insurance. So that more than made up for the deficit, meaning the finding that he could only afford $2,500 a month also wasn't supported by competent substantial evidence, because his own evidence showed that he could afford the $3,500 a month. And the problem that we have here is what was recognized by this court in the Zonavoy versus Zonavoy case. It's an abuse of discretion to award alimony that leaves a former wife unable to meet even half of her expenses, while the former husband enjoys a level of affluence that far exceeds that of the former wife. And here, when you consider the tax credits, former wife is netting $2,300 a month in alimony, and former husband is netting $9,200 plus after the tax implications are considered. And this is the type of disparity that Zonavoy recognized as too great to ignore. I do think that it appears that the trial court was punishing the former wife for her actions. But as I mentioned before, there's not competent substantial evidence to support that she engaged in wasteful conduct with respect to the credit cards. It was undisputed that at the time of the dissolution, the former husband closed access to the joint bank accounts. He closed access to all the credit cards. And
I
when
think
you
the
look-
evidence suggested that he was closing those things because in his view, they were being abused and they were.
he closed them at the, I'm sorry, Your Honor, he closed them at the start of the dissolution. She then opened additional credit cards, which he then closed. In the time period when she had the additional credit cards, and this is an exhibit that the former husband put into evidence, she was spending roughly, I want to give you the exact amount because I don't want to quote it wrong. It was roughly $4,000 a month on the credit card. I'll find it exactly because I want you to be able to see this. On his exhibit, which was at the evidence record 4582, the amount that she spent on the credit cards for the 9 months between April of 2015 and January of 2016 amounted to about $4,800.04 a month. I'm sorry, $4,804 a month. That is what
was
she
on
had.
the credit cards.
That was on the credit card,
And
but that's
during
what.
this period of time, did she also not have access to the $160,000 of proceeds from the sale of the Nebraska home?
She did, Your Honor, but the law is clear that a party is not required to spend down their liquid assets in order to survive.
Well, except for that, she had these proceeds pursuant to the marital agreement that they had in place, not pursuant to a court order, right?
Correct, but those were liquid assets that she should not have had to spend to survive, and which she did spend to survive.
But let me ask you this. I mean, she had them pursuant to a marital agreement that had yet to be affirmed by the trial court. So at the time she had access to those, they were arguably marital funds, were they not?
Your Honor, they arguably were, but when you have to look at what she knew and understood, which is that she believed she was operating under the terms of the agreement, which gave her the exclusive right to these funds. And regardless, even though she shouldn't have had to use them, there's no evidence other than the fact that she used them entirely during this 3 years of the dissolution proceeding. Yes, she first transferred them out to her mother, but that should not have been the end of the inquiry, because she testified repeatedly that she had to use the entirety of the funds. And she said that in her closing argument. She reiterated that these funds are gone. So, you know, even when she was able to pare down her expenses to $9,000 per month, the amount of alimony that she's getting, and once the former husband cuts off all the credit cards as of January 2016, she has no ability to pay for her living expenses beyond the $3,500 other than to tap into those funds, and those funds are gone. And that's why when you circle around to the equitable distribution argument, that it was error to assign those depleted assets to her in the equitable distribution scheme, because it's error to assign a depleted asset. It's only if you find misconduct, which, although the trial court did, that finding was not supported by competent substantial evidence, because transferring the funds to her mother should not have been the end of the inquiry. They should have looked at what happened to the funds after that point, and if they were used to support her during the dissolution, and it's a 3-year period.
But how is that something that can affect our review of what should have been fleshed out? I mean, as our review is whether substantial competent evidence supports the finding of misconduct, not whether there could have been countervailing evidence that undermined that.
Well, Your Honor, it's not that there was countervailing evidence that undermined it. She testified that those funds were gone. There was no evidence that they were not gone. Obviously, the wife struggled to put in her evidence during trial, but there is direct testimony, which is evidence that those funds were gone, and there was no counter evidence. So the only evidence before the trial court, other than speculation as to, well, maybe the funds are still there, maybe they could have been used, was that she had to use those funds to support herself due to inadequate support. And you see from her financial affidavits that she, yes, Your Honor, did you have a question?
No, thank you.
Oh,
Yeah.
Okay, sorry, I thought you had a question.
I have notes. I look at my notes. And
Okay, she was had expenses of roughly $9,000 per month, which is equivalent to what the former husband said his expenses were. And so I don't think it's unreasonable to say that she had the same amount of expenses that he was running per month. But she had to get the money, that deficit of $5,500 from somewhere. And she testified that it came from those funds, that those funds are gone. And so there's no competent substantial evidence to support the finding that those funds were wasted, because using money for your support during a dissolution is not waste. Waste is where you use marital funds for an affair, or, had she placed the money, given the money to her mother and the money was still sitting there where she could access it, but it still existed, then that might be a different story. But there's no evidence that that is the case. The only evidence is that the money is gone. And that because it was used for her support during the dissolution. And as such, it's error to assign that asset to her in the equitable distribution scheme. As to the retroactive alimony, again, as we argued in the brief, the trial court made no finding regarding need and ability to pay with regard to retroactive alimony. The finding was simply that none would be owed because there had been support made and car insurance payments and various items had been paid. But it was incumbent upon the trial court to still look at need and ability to pay during that 1-year time period for when the dissolution was filed in 2015 until temporary support was ordered in June of 2016. And we know from the husband's own records that during that time, he was paying very, very minimal amounts towards her support. And this is what caused her to incur the credit card debt. He was paying less
But he
than...
ended up being responsible for that debt, right?
Well, he did.
Right. So, I mean, he paid minimal amounts because she's running up credit cards, which he's paying, and she's going through the Nebraska home sale proceeds, which have not yet been pronounced by a court to be non-marital. So that's, again, reading a cold record, that's what it looks like that the trial court was persuaded by. So help me understand that better.
Yes, Your Honor. When the husband initially cut off in 2015, cut off the access to the joint bank accounts and the access to the credit cards, Ms. Duhamel incurred, that's when she was incurring roughly $4,800 a month in credit card debt, because at that period in time, and you must remember the former husband testified he didn't know about those credit cards. So he's paying her less than $1,300 a month. And in fact, from his records, in June of 2015, and this is page 4476 of the evidentiary record. In June of 2015, he gave her $1,500. In July and August, he gave her no money at all. And so, and then there's...
He also knows she has $150,000, $160,000 worth of proceeds. And so she's likely not to starve. She's got this big cache. Again, I know the argument is she shouldn't be spending it.
Absolutely. Not only should she not have to spend it, but he's been the primary breadwinner throughout this marriage, and they haven't had to touch those proceeds for the 2 years that they've been sitting in her account while she's been married. So if he hadn't cut off her access to the funds in the first instance, we wouldn't have seen this credit card debt running up at $4,800 a month, which makes perfect sense when you're not getting any money at all. I mean, the trial court is punishing her for needing money to live and trying to hold on to the nest egg that the parties have had, that they haven't had to spend while they were married, and which the case law says she shouldn't have to dip into in order to survive. So knowing that she has never worked, that she's not going to get retirement, and trying to preserve as best she can the liquid assets that are available. I mean, the husband supported her for 28 years of marriage, I believe. And And so it's not unreasonable to expect him to continue to assist in her support during the dissolution. And yet the trial court punished her for exactly expecting that. And once those credit cards were cut off and she was only awarded $3,500 a month in temporary alimony, she then had no option but to dip into the funds. And those funds, as she testified repeatedly, are gone. But again, that non-existent asset was equitably distributed, meaning she received—
You're at 15 minutes right now, just so you know. The rest of the time is yours to use if you want. But it concerns me you haven't gotten to the issue of reopening her case.
Okay, then I will
That's the
briefly
issue
address
that I'm
that
very
because
interested in.
I do. Okay. Yes, Your Honor.
So you want to keep burning into your time?
Yes, I will,
Okay.
because I do need to address that if you're interested in it. She moved 5 or 6 times to reopen, 6 different times to reopen her case. She, in attempting to present evidence, was told by the trial court that certain evidence would need to come in through the former husband. Being pro se, she did not understand the procedural technicality that she had to call him directly as a witness in order to present her evidence. She thought that she could do it through cross-examination and rested her case. When that error was brought to her attention, she asked repeatedly to reopen her case. She explained that she explained her thought processes at page 6984, at page 7114, she asked to call him as a witness. At 7145, there was an extra hour and a half of time where she asked, can I just use that? And it was denied because the former husband objected. She asked to reopen after the husband rested at 7510. And so repeatedly, she's asking to reopen her case. And it's a denial of an abuse of discretion to reopen the case where will not be unfair prejudice to the opposing side. But the evidence would put forth additional information that would be pertinent to the fact finder. And she listed out, fortunately, the trial court let her do it on the record at page 7511 on all the evidence that she wanted, including valuations of the account, the bills the husband wasn't paying that forced her to incur the credit card debt, various charges he made to the credit cards. And there was there wouldn't have been any unfair prejudice to the former husband. The only thing that's been argued as unfair prejudice in the brief is that there were 36 more exhibits that she wanted to introduce, but the former husband introduced 87 exhibits, and even with the one she had already entered, that would only bring her total to 64, so still substantially less. All of these exhibits had been disclosed. And so there's no finding of prejudice, and it's certainly, the trial court being presented with all the case law and all the argument, and her asking so many times before, former husband's case, certainly before the case was concluded, the trial court abused its discretion in not allowing this. And if you have specific questions, I'll answer them. But
well, you're right at 18 minutes, so I don't want to do that to you. You got 2 minutes for rebuttal, okay?
Okay, thank you, Your Honor.
Okay. So, Ms. Lastly, you ready?
Yes, Your Honor. Your Honor, may it please the court. I'm Mindy Lastly. I represent the former husband in this case, Dr. Duhamel. I would like to point out a few of the main issues here because they pertain to almost all the issues and arguments that the former wife cites in her brief. Essentially, Your Honor.
Do you mind if I jump into your argument a little bit?
Of course not.
Because I am concerned about the failure to reopen the case. Okay.
Absolutely.
This is a pro se litigant who
Yes,
basically is getting ready to try to put in 36 exhibits through herself. The court
Yes, Your Honor.
tells her you can't put them in through yourself. You need to put them in through the husband. Not being a lawyer, she doesn't know that she can't wait for the husband's case in chief and try to put it in through her cross-examination of him. And she learns that the hard way. She rests her case. She figures he's going to, testify in his case because he's the other really main witness. And when she tries to do that, she's told she can't. She then 5 or 6 times tries to reopen her case. court doesn't let her do it. This seems
Yes, Your Honor.
really harsh to me, really harsh, because those 36 exhibits and the testimony she was going to get through the husband were critical to her case, and they were all fully discovered, known to everybody. Nobody's surprised. And this judge wouldn't let her do that. I'm bothered by that. So go ahead.
Yes, Your Honor. Well, Your Honor, essentially this, pertaining to your question specifically, this was a 6-day trial. When resting her case after 2 days, the judge specifically asked her, do you rest your case? And told her essentially what it meant to rest her case. During which I'm sure, which was cited through my answer brief, during that period of time on the 5th day of trial, I was approximately, and I was the trial attorney, as I'm sure that you saw, I was approximately 2/3 of the way done from completing my direct examination of the husband. The wife at that point storms out of the courtroom and she tells the judge that she can go ahead and she's going to hire an attorney and appeal the case. This is after the former wife has delayed a case, a simple case just involving equitable distribution and alimony and attorney's fees, which there was already a temporary attorney's fees hearing in which that was denied. No children, minor children, mind you. And at that particular point, she says that she's not going to participate. There was a 6-day trial. She may or may not show up the next day. She was given a chance.
She said the kinds of things that very frustrated lay parties will say.
I'm sorry, Judge, I didn't hear
Well, she
you.
said the kinds of things that very frustrated lay parties will say in litigation because they're frustrated because they're in unfamiliar territory. They feel they're being outgunned by the lawyers and the judge in the courtroom. They know all the rules and they don't. And yes, she got frustrated and she, did something that a lawyer shouldn't do and wouldn't do, but she did. And she was a lay person. She had a lot at stake here and she felt that she was being prevented from putting on her case.
Well,
So
Your
I
Honor,
don't condone what she did, but I understand it.
yes, Your Honor. On the 6th day of trial, on the transcript, the judge, not just the particular site that was referred to by the former wife, the judge let her proffer all of the evidence that she wished to submit, including that the former wife showed up with 2 additional notebooks. She said that it would be another day just to admit that, her additional evidence. And no, that was not evidence that had been previously disclosed. And it would take additional day for her to admit that, not including cross-examination. Your Honor, this was after the pre-trial had been set and continued 3 times. This is after the trial had been set on 4 different occasions, 5 motions to recuse the prior judge, in which Judge Lewis finally voluntarily recused herself, and a pattern of just delaying this process. My client
What's the
is from New York.
What type of injustice or prejudice justifies denying a request to reopen, and what type of injustice or prejudice is the type that you get my point?
Yes. All right. Well, my client's from New York. He has had to take off work on numerous occasions to fly down here for these hearings. He's, not to mention the expenses that he's had to incur in doing that. This has just prolonged this case. She has benefited from this. For example, is the alimony argument. Her rent had been $1,300 a month, the same as my client's for years. By the end of the case, it had then been $1,800 a month, referring to the passive appreciation from the former husband's Nebraska accounts. Obviously the buyer's case has been cited.
Is that the type of prejudice and injustice that justifies denying the request to reopen, or would it be some sort of?
That would be a benefit to her, Your Honor. That'd be a benefit to her, Your Honor. And I was going to cite from the buyer's case, I was going to then cite from that case, I was then going to cite the Perlmutter case by her delay, essentially, and her request to extend it. That would be another reason that that's prejudicial. And also, obviously, Your Honor, the client, the former wife had funds available, as you mentioned, that were in an account that would have been able to accrue interest or whatnot. That's prejudicial to my client as well. But I mean, to get more to your point though, Judge, this had gone on for 3 years. Arrangements had been made for it to be extended. It had started, the trial itself had started in June. It had then been extended to July. Mr. Fluke, she had already had 3 attorneys, then another attorney for a motion for rehearing. And then Ms. Harrell is now appearing, the 5th attorney. In 2016, Mr. Fluke said he was ready for trial, and it's been continuance after continuance. At one point, she said that she wanted to be there. She wanted an actual 5-day trial where she just wanted the trial to be half a day per day. And at this point, my client would have to fly down to spend the time to actually have to do a trial for half a day. And after hearing all of the evidence that she wanted to submit and the 2 additional notebooks, and it was actually 3 to 4 additional documents, it's prejudicial to my client. Your Honor,
Well, I guess one of the good things about that have come out of COVID-19 is the fact that we now know how to do all this remotely, and things like this should never happen again.
I'm sorry, it should never happen.
I said one of the good things that have come out of COVID-19 is that the courts have been forced to learn how to do all manner of things remotely, and something like this shouldn't happen again. He could have had the entire trial done remotely from Ithaca, New York.
Well, that was not the situation.
I know.
And regardless,
it's an irrelevant comment on my part.
Oh, I mean, the longer something progresses, for example, Ms. Duhamel knows that my client gets a raise. Obviously, we disclose that. I mean, another reason that the case was prolonged that I would submit to the court. However, in terms of this being prejudicial, you also have to consider that the court has broad discretion in determining that. The cases
yeah, the
that
court
are cited
does have broad discretion, and the standard here is abuse of discretion. But,
yes, Your Honor.
but to reopen a case to allow a lay litigant to put in a substantial part of their case, which they tried to put in, all of which has been discovered, no surprises. I mean, you know, to reopen a case in this context should be liberally granted. I think the case law would support.
Your Honor,
it appears that the judge might have been tired of this difficult litigant at this point.
Your Honor, I don't know how to say this, but with all due respect, I have to disagree. I believe that Judge Polk went above and beyond. I know there's case law that says that in a pro se litigant should be given leniency. The trial court specifically said, I need you to submit evidence as of what you need. What do you need? In this particular case, the former wife even denied, as a petitioner, and her address was in Florida, she denied that she was a Florida resident. It got to that.
That goes to something that your answers had made me think about. A lot of what you're saying is seems akin to an argument that she's abused the process or engaged in dilatory tactics. But that would be maybe a separate reason for denying the request to reopen. What I'm asking is that what type of prejudice, is prejudice extraneous to the litigation sufficient? In other words, well, it is an inconvenient, and I'm not denying that it was an inconvenience and a cost to fly down. But is that type of prejudice the type of prejudice that we should take into consideration, or should we take into consideration prejudice in the defense or prosecution of the case? In other words, in order to justify denying the reopening, does a party have to be prejudiced in its defense or prosecution of the case?
Both sides, the prejudice should be, yes, the case law says both sides, the court has to determine the prejudice. The court had, one of the issues was obviously how long the case had been. It wasn't an issue where the judge was just frustrated. The judge had given extreme thought to this case. This case was something that the court had mulled over. This is something that the court had heard for an extensive period of time. This is something that my client had to come and expend significant financial resources. There was a discovery deadline. There was a deadline to exchange financial documentation that was done. However, when she came in, she had 2 additional notebooks on the 6th day of trial, and that was not information that she said that we previously had. The 6th day of trial, and again, this is not what was cited, that Ms. Harrell had just previously mentioned. She mentions all these different valuation dates. She mentions issues as witnesses she would want to call as to the credibility of my client. Then case law is discussed, the Buckingham case specifically. The case law that's discussed in terms of cited by Ms. Harrell, I mean, we have the Delgado case where, I mean, you know, a first-degree murder case, there wasn't a jury instruction regarding a self-defense issue. You know, we have a situation where there is a couple pieces of evidence. I mean, even though, yes, she's pro se, I mean, she's gone through several attorneys and she was afforded great leniency. And however, though, the abuse of discretion of the court process, at some point, enough is enough. Exactly how often and how much does my client actually have to spend to come down here to relitigate this case after so many continuances? This was something that would go on forever.
Ms. Lastly, you're at 13 minutes and 40 seconds, and you've spent all your time on this issue. I just want to focus you on that and give you a chance to talk to other issues if you want to do that before you run out of time.
Yes, I would, Your Honor. Judge, as to the alimony issue, and again, some of this I briefly mentioned, as to the fact that the case had been prolonged. Obviously, we have the situation, and I know Ms. Harrell said that there was no competent substantial evidence that the funds, which totaled $176,000, were actually gifted to third parties. However, they were indeed done so. In the transcript, it's very clear that they were done so. At certain points, she said, and which were cited to in the temporary relief hearing, that she did so knowing the case was going to a divorce. And so what happened is she gifted the funds. She even said that she was doing so to buy a retirement home with her mother. That was not done. And then at the same time, I'd like to point out that she also had a power of attorney over her mother as well when she gifted the fund. She was also gifting $15,000, which she did to her 3 adult children. If she had the ability to do that, what need would she have in any alimony issue, which is what the court first has to determine. The court first has to determine what the need is. And during the pendency of this case as well, Your Honor, the former wife's rent went up as well, the $1,800. If she had indeed done what she said that she was going to do, and if she had purchased this home, then she wouldn't have a situation where she would even have a rent payment. I I mean, we're talking $176,000 that she gifted. I mean, it's been referenced that she used these funds to, had to invade these funds that were marital for support issues. Yet at the same time, it's also been said that she had to use credit card and incur credit card expenses at the same time to fund her living expenses. I mean, essentially, she's talking out of both sides of her mouth. In terms of the credit card expenses, that argument for retroactive alimony as well, when it comes to that portion, Your Honor, before the filing of the divorce, the former wife's credit cards amount, the debt that was owed was $3,217.84. The husband's were $9,250.76. That was in April of 2015. And then what happened, and that included, mind you, that included the credit card debt from the wife, that included plastic surgery, LASIK surgery, and a gastro bypass, I believe is the politically correct term to use. That then jumped to $43,236.44, in which the wife either reactivated credit cards that had been closed, opened credit cards in the husband's name, or transferred credit cards into the husband's name. And this was done without his knowledge. So they were done also where it was initially 0% interest, but then after so many months, the interest rate would increase. And as the case progressed and progressed and progressed, then the interest would increase and increase as well. Therefore, his ability to pay, any alimony would obviously decrease every time we would come back to court. So this was not the former husband just paying the normal living expenses. And it wasn't just $1,500 a month during the period that Ms. Harrell stated. He was also paying expenses, and I mean, to be specific as to the expenses that he was paying for her in terms of the $1,500 a month, which, yes, the court, it was not brought up during the trial, but I mean, in which the court has to determine the retroactive alimony. He was paying during that time period health insurance. During that period, it was $16,267.68. He paid $117 for car insurance. I'm sorry, for life insurance. He had paid off her car during the pendency of the case. The car insurance during this period, in which allegedly he was just giving her $1,500, as Ms. Harrell stated, he paid $4,770.87. The car loan, over $11,000. And then he was paying this credit card debt, which was from the transfers as previously stated, which was a little over $25,000. This was not just regular expenses that were for marital purposes due to the fact that he was the breadwinner. And then obviously we have the temporary relief hearing where he was paying the $3,500 a month, in addition to the regular expenses and the credit card expenses at that particular point, which were going up exponentially due to that. And at the same point, obviously—
You're at 20 minutes, so your time is up.
All right, Your Honor, I would just add that the court went through this meticulously after thoughtful review and with competent substantial evidence. She made her ruling, and this should be affirmed.
Thank you. Ms. Harrell, you have 2 minutes.
Then I will try to wrap up quickly. I wanted to address Judge Atkinson's point about what is required to show prejudice in order to deny a litigant the opportunity to reopen their case. And I would address or direct the court to Hernandez versus, I can't pronounce it, Casiamani Development Company, which is cited in the brief, my initial brief at page 27. that says, while reopening a case is prejudicial to the opposing party, it is only unfair prejudice that will prevent its happening, such as where the non-moving party can no longer call a necessary witness. That's not the type of prejudice we see here. And I was thinking that an analogy.
Can you just cite to that case again, please?
Yes, it's 698 Southern 2nd, 927. And that was at footnote 1 in that case. Sort of analogous is, when you have a petition for cert, you have to show that you will suffer irreparable harm, and the incurring of attorney's fees is not irreparable harm. And so it's hard to sort of equate incurring attorney's fees that should have been expended had the party followed the proper procedures. Had she known, those fees would have been expended anyway. And as I pointed out in my brief, this was originally set for 4 days. The former wife used 2 days. When the former husband ran longer than 2 days, the trial court managed to find an additional day and a half of time for him, but would not even give the former wife an additional hour and a half when she requested it, and that time was available at the end of the day. So you can see the plainly disparate treatment. I know that the additional records were addressed, and you can see in the transcripts what had happened was the former wife was trying to introduce incomplete documents, and she was not allowed to do that, where they were missing perhaps the end pages of a credit card statement. And so she was just trying to correct, again, another technicality.
You're 2 minutes.
Was there. So, Your Honors, we would ask that you reverse and remand this case so that she has a fair opportunity to present the evidence that she needs to support her case.
Thank you very much. Thank you both. Tough case, well argued. We appreciate it very much.
Thank you.
We are adjourned to deliberate these cases.
Thank you. Have a good day.
You too.